My name's Susan and I've been in HR for the last 12 years. I'm a HR manager for two companies down in West Sussex. One of them is the Learn Centre and the other one is a larger company which has about 2,000 remote workers that work on other clients' work sites every day. And then we have a head office which I'm responsible for in a very small village down in the country. So the Equality Act is what you're here for. Anyone have any major concerns about the Equality Act that I hope I'll be able to address, or is it just a general overview of what's going on? Yeah. Okay, so the Equality Act came in October last year, and it is essentially restating everything that has already been made law over the years, but the laws have been coming out gradually and slowly over the last 30 years. The first discrimination law was coming out in 1975, 1976. We had Equal Pay Act in 1970. And as case law has occurred, they've had to bring out new legislation to do with combating discrimination in the workplace. So the Equality Act is trying to get it all together in one place, harmonising the approach, which is mostly to do with how the lawyers would take things to court and how tribunals would cope with them. But there are some extensions in it, which is what I'd like to cover mostly, because I'm sure that you will already have had in place something to do with discrimination with regards to all the normal things that have happened over the last few years. So there's some extensions, and there's another reinforcement in law to say that it's really to encourage employers to take positive action where they can to help with overcoming disadvantages. These are the protected characteristics, which should be fairly familiar to you. There's nothing brand new there, but there are some tweaks which I'm going to go into in more depth. So the sex and the race and the pregnancy and the marriage, that's all been there over the years. There's been amendments as we've gone along. Also, the Equality Act, I'm sure, will be amended come a few more years' time as case law comes through. But with those protected characteristics, you've got the prohibited conduct. So the major one is discrimination, and it's about less favourable treatment. Direct and indirect, you're going to have to sort of wink at me if I'm teaching you to suck eggs. So you've got the direct and indirect discrimination. Perception, assumptions, we know is unlawful. We also have association now, and that's if you are discriminating against someone if they are associated with someone else who is a part of a protected characteristic group. An example of this would be someone who's coming in late all the time in my office, and I don't bother to check that the fact is the reason they're coming in late is because they're actually caring for a disabled person at home. So association with a protected characteristic is something to look out for now, I think. And there's a new form of discrimination which can be classed as arising from a disability. So we will go into that in a bit more depth as we go along. The other two areas of prohibited conduct is harassment. That's been around for a while, and victimisation. The harassment, as you saw from that first picture slide, is not necessarily the recipient of the behaviour that has to feel offended. And I think that's a tricky one. So if banter and teasing is going on in the office against or towards a certain individual, but they've got no problem with it, but there are people around them that are finding it offensive and intimidating, you have got an issue there. So the key words is hostile, intimidating, degrading, humiliating or offensive. And you have to obviously be aware that some people's levels and boundaries with regards to teasing and jokes is different to others. Okay, so I've put there no bully zone, but that's a bit of a strong word. So you've got the harassment and victimisation as well as discrimination, all unlawful. But those protected characteristics list, as I said at the beginning, they're elements that came out in their own particular laws. They've been unchanged. So it's been the Equality Act is restating what you already know about those areas. What has changed is in the area of disability. When someone is classed as disabled, in law previously they had to pass certain tests. It was continence, mobility, dexterity. Were you aware of those? Come across those before? Yeah. Now it's just this blanket definition. It's a substantial and long term, and it's got to be an adverse effect on ability to carry out day-to-day activities. So you may find that if someone wasn't classed as disabled before, they might now be thinking, maybe I could be classed as disabled under this new definition. And that's what I'm thinking in the workplace to look out for. Arising from disability is new under the Equality Act. You've got to investigate things, I think, a lot more before you make decisions. So why am I going to be treating this person in this way? And is there any chance that it could be because of something that is arising from maybe a hidden disability that we don't know about as managers? And associative discrimination, which I mentioned previously. There may be somebody at home that this person that you're about to make a decision on is connected to. So it's about talking to people, and it's best practice anyway in the workplace, in management. With regards to the questions we like to ask before we hire someone, how many of you are recruiting managers? Do you recruit yourselves? And do you like to ask before you see someone, or at the interview, how many days off have you had last year?
I used to have it in my application form.
Has it been taken out? Yeah, that's good. We have got some options when we can ask questions, but they have to be very, very tight and specific to the role. So you can ask before you get someone in to interview for a scaffolder. You can ask on your application form whether they have the ability to climb a ladder, but you can't ask general health questions. It's got to be absolutely intrinsic to the role. You can also ask questions if you're likely or you believe that you may have to make some reasonable adjustments to both the interview process, your location perhaps, having to walk up some stairs to the interview room, bright lights, and if there's a test, if you're going to be doing a test in your interview, you may want to ask some specific questions about, do any reasonable adjustments need to be made for any disability or any other reasons. There are some other defences there to monitor diversity in applications and to support positive action. I'm going to go into positive action in a little bit more depth a bit later, but those are the only reasons that you would be able to ask about health, and I think the key here is just to keep it very, very specific to the job. Gender reassignment, protected characteristic, but now the individual that is going through a transition from their birth sex to the opposite, or perhaps the other way, going back to where to what they were born as, whatever happens there, they don't have to be under medical supervision to be classed as a transsexual. So there's usually quite a long period of time where they live as a person of the opposite sex before they start to have medical treatment. So from day one of that, it's a permanent choice, it's a permanent change, and you can't discriminate against them. They're obviously protected now. Cross-dressing is not classed in this area, so someone who chooses to occasionally change the way they dress and act, that's not the same. So it's a permanent life change. Tribunal powers. I'm not sure whether you have ever had the privilege of attending a tribunal. Have you? No? Nearly? It's exciting, isn't it? So whether you know this or not, but previously the tribunal's powers basically have been extended, and if you do ever get there and the claimant has done a pretty good job at putting themselves forward, you could be faced with having a recommendation that you have to go back to the workplace and put in place for the whole company, whereas previously it would have been, you've got to go back and make this change to make this situation better, different. So a lot more power there. So I think that employers that do face the tribunal chairman will get more than a little slap on the wrist. It's going to be a huge thing to go back and change. Equal pay. This is an odd one. Direct comparators previously. Now it's saying that you don't actually have to find a real person to be your comparator if you're thinking of going, this is an employee going to make a claim. But if they can prove that they would get more in their package if they were of the opposite sex, they can have a go. They can go to tribunal. So it'll be interesting to see how many more claims come out of that. The lawyers are going to be busy.
There's one on at the moment, I think, in sort of West Midlands area where some healthcare assistants are saying that their equivalent to like England or something like that.
Yeah.
And therefore should be paid the same.
Yeah. So it's opening up some floodgates that never before. So it'll be interesting to see how it goes. Pay secrecy. Have you got pay secrecy clauses in your contracts? No. No.
I have my clause.
You do? Yeah. There's two types. There's one which is maintaining confidentiality in the company against third party, i.e. competitors. So the employers can ask or make it into a contract that you don't share confidential internal data with the outside world. But what the Equality Act is saying is you can't stop your employees from talking to each other about what they get. And they do anyway. It was never very easy to enforce, and I don't envy anyone who tried to enforce it. So going forward, if you did have them as a standard in your template contract, you'd probably want to take those out because they're not worth anything now. Positive action. Has anyone ever attempted to try and plan a positive action? I know I haven't in my years. It takes quite a lot of analysis of your company. Are there any protected characteristic groups that are disadvantaged by any of your processes or policies? And then you would go forward from that, having identified it, and then you would put into place to allow the disadvantage to be overcome or minimised. And then, of course, what the Equality Act is saying, and it's trying to reinforce to employers, is don't be afraid to do this. Because the people that weren't in that protected characteristic can sometimes get all a bit up in arms and say, well, you're treating them more favourably, and it all gets a bit messy. But positive action is certainly lawful and is encouraged.